New York felony sex crimes attorney Andrew M. Stengel. Part 1. An overview. Consent is usually the crucial issue in felony sex crimes cases. Under New York law, lack of consent is defined by forcible compulsion or an incapacity to consent. Forcible compulsion is defined as the use of physical force, even if minimal, or a threat that places a person in fear of immediate physical injury, death, or kidnapping to themselves or another person. Incapacity to consent is due to a person being less than 17 years old, mentally disabled, mentally incapacitated, temporarily incapable because of the influence of a narcotic or intoxicating substance given without a person's consent. Physically helpless, either unconscious or unable to communicate an unwillingness, or, in certain institutional settings, like in police custody or in state or local prison. The most commonly charged felony sex crimes in New York are rape in the first, second, and third degrees, sexual abuse in the third degree, aggravated sexual abuse in the first, second, third, and fourth degrees, criminal sexual act in the first, second, and third degrees, facilitating a sex offense with a controlled substance. The differences in the felony sex crimes charges depend on the alleged act combined with the lack of consent. Rape involves sexual intercourse, penetration, however slight. Sexual abuse involves sexual contact, touching sexual or intimate parts either directly or over clothing. Aggravated sexual abuse involves inserting a foreign object in a person's sexual parts, except for a medical purpose. Criminal sex act involves oral or anal sexual contact. The most important evidence in an alleged sex crime investigation or prosecution is the statements of the complaining witness. In addition to these statements, there are several other kinds of evidence that prosecutors typically use during an investigation or at trial to corroborate the allegations of a complaining witness. If the defendant and the complaining witness are strangers, a prosecutor will seek an identification of the defendant, DNA evidence, surveillance video, and even cellular phone location data. If the complaining witness and defendant know each other, the type of evidence that prosecutors seek may differ slightly than if they are strangers. In such cases, consent or lack of consent is often the key issue. Prosecutors may also rely on statements made by the complaining witness to medical professionals, 911 calls, and photographs. In addition, prosecutors will search for any statements made to others in the immediate aftermath of the alleged acts. These statements may include oral, in-person, or phone conversations, text messages, emails, or even social media posts. Prosecutors will also seek DNA evidence even if the complaining witness and the accused know each other. The New York Sex Offender Registry. Sex offender registration is mandatory for those convicted of a felony sex crime. Registration is for 20 years or life, depending on the risk level assigned to the offender, 1, 2, or 3. Level 3 offenders are high risk and Level 2 offenders are moderate risk. Both must register for life. Level 1 offenders are deemed low risk and must register for 20 years, unless they are designated a sexual predator, sexually violent offender, or predicate sex offender. Failure to comply with registration requirements is a crime itself and carries increasingly serious penalties with subsequent offenses. In addition, conditions of probation or parole associated with a sex crime may be very strict, including limitations on where the probationer or parolee is allowed to live and restrictions on the use of the internet. A felony sex crime conviction carries serious consequences, including a possible mandatory prison sentence, burdensome terms of post-release supervision, and a lifelong obligation to register as a sex offender. However, an arrest and prosecution for an alleged felony sex crime doesn't necessarily mean that a conviction will result. A skilled criminal defense attorney may be able to prevail upon a prosecutor to having the charges dismissed prior to trial. Convince a prosecutor that the evidence proves your innocence or that the case is unlikely to be proven beyond a reasonable doubt at trial. Negotiate with the prosecutor for a favorable plea bargain to a lesser offense, perhaps avoiding status as a sex offender. As a former prosecutor and current criminal defense attorney in New York, Andrew Stengel has aggressively and successfully handled hundreds of accusations of sex crimes. Visit the website of Andrew Stengel for more information, STENGELLAW.com, or send an email to info@stengellaw.com. Attorney advertising. Prior results do not guarantee a similar outcome.